Did you know that a single clause buried in your real estate contract could stop you from working in your city for a year or more? I'm talking about a non-compete agreement. And if you're in the business world, you need to know where things stand right now, especially with the new rules of the Federal Trade Commission, which are causing a legal storm. Hey there, I'm Kyle McCutcheon with Provident Law, where we help professionals like you navigate legal challenges of the Arizona business world. Today, we're diving into non-compete agreements, what they are, how things have been shaken up recently, and what that means for your contracts, your careers, and your company. Non-compete clauses are generally contract provisions that stop someone from working in the same industry or geographic area after leaving a job. For example, in real estate, they're often used to prevent former agents from talking to clients or competing nearby. Or in the business context, it might be used to prevent a fitness instructor from leaving and opening a gym with clients from their former gym. But here's the deal. These clauses are only enforceable if they meet certain conditions. They generally have to be reasonable in time, geographic scope, and activity. And under Arizona law, they must protect a legitimate business interest, like proprietary information or client relationships. And even when they're written well, courts can blue pencil them, which means they can strike out parts that are too broad, but still enforce what's reasonable. Last year, the FTC dropped a bombshell, a nationwide ban on non-compete agreements for almost all workers. The rule was supposed to kick in September 2024, but guess what? It hit a legal wall. A Texas federal judge ruled that the FTC overstepped its authority and enforcement of the rule was blocked nationwide. Now the FTC has appealed and the outcome is still up in the air. To complicate things, the FTC's new chair, appointed by President Trump, isn't exactly a fan of sweeping regulatory rules. So what does this mean for you? Time will tell. It's possible the FTC drops its appeal, but that might not be the case. And that safety net could vanish if you're an employer relying on a non-compete provision. And if you're an employee stuck in one, light might be at the end of the tunnel. Whether you're trying to enforce a non-compete or break free from one, here's how I can help. If you're an employer, I review your contracts, tighten up your confidentiality and non-solicit provisions, and ensure you're not relying on a clause that might not hold up in court. If you're a worker, I'll explain what your agreement actually says and whether it's enforceable and what options you might have to move forward. These agreements don't have to be career killers, but you do need a strategy. So non-compete agreements can either protect your business or hold your career hostage, depending on your own situation. And with the legal landscape changing so quickly, you need more than just a handshake deal. You need legal clarity. So let's talk. Whether you're drafting new contracts, reviewing old ones, or dealing with a dispute, reach out to me at Provident Law and let's make sure your rights and your future are protected. And remember, legal knowledge is power, especially in this environment. I'm Kyle McCutcheon, attorney at Provident Law, and I look forward to assisting you.